Thank you, Lionel. It's about time I did a contribution to the seminar series, I guess, considering I've been enjoying your hospitality and the faculty's hospitality for 2 years now. Just a few caveats before I start. You'll probably find I have a fairly continental outlook. Obviously, I know Dutch copyright law quite well because that's my sort of native domain. But we have done a lot of work on EU harmonization at the Institute for Information Law, as Lionel mentioned. And just to give you a sort of placeholder, the first more or less mature Dutch Copyright Act dates from the late 19th century. Already then the legislature and doctrine and the courts were fairly open-minded about importing foreign concepts into copyright law. Especially from Germany and France. Generally, most Dutch copyright lawyers are more familiar with the big sort of continental copyright traditions, the personality-based conception of copyright, if you will, rather than the common law traditions. And another thing I want to say, because I'm always confused about the UK Copyright Act because it's such it covers so many areas, is that I'll be talking about copyright proper. That is, I'll not be speaking of related rights. It'll be about literary and dramatic and musical works, as you would say, and not about the rights of phonogram producers or performers and so on. One special reason why we're interested, or I'm interested, and I guess Lyle and Elena also, in this topic, is because of this multidisciplinary research project that we are doing under the HERA program of ESF, and it's a program that's funded by a number of national research councils which work together in the European Science Foundation, and they started a program on creativity and innovation, and here's some of the blurb. And it's made up of 3 linked projects on authorship and the work as creative expression. One of the reasons why we choose this focus was because in the beginning of 2009, when we were actually writing the grant application, the work and authorship seemed 2 concepts that had been barely touched by harmonization at the EU level. Compared to the scope of rights and limitations and duration. And that made it more interesting to look at, because so much of the recent research on European copyright has been on rights and limitations and enforcements and on adapting copyright to the digitally networked world, and the concept of work and authorship, which are pivotal concepts, of course, in copyright, seem to have gone without much notice in the past years. And considering that the history of harmonization by directive shows that it's often a lengthy process and it's getting more complex as the EU expands its membership, frankly, we didn't expect there to be much development in EU law over the course of our project, and it started last year and it ends in 2013. And boy, were we wrong. This has led to, for me at least, some changes in sort of my work schedule, because we've had the Infopack case and the most recently the Murphy case. We've had BSA is an important case, and there are more cases in the pipeline which will all be important on the concept of what is a copyright work. So that's what my talk is about, is the Court of Justice telling us what a copyright work is. And at first glance, you might think, the title I gave for the talk is kind of a rhetorical question. Is it fragmenting or integrating the notion of copyright works? Integrating, surely, you might say. And it seems the obvious answer, but opinion in doctrine is actually quite divided, at least on the continent. And one can also ask whether the court's judgments actually result in any real changes on the ground, so to speak, in domestic courts. As far as I can see, and there's a slow trickle-down process, so there's not that much local case law which incorporates these European judgments, but Dutch courts, for instance, they just tend to take on board the terminology and apply it in addition to all the sort of landmark criteria we already had, and just go merrily on their way, so that not much seems to be changing. So what I propose to do in this talk is give a brief sketch of the landscape of EU directives. Most of you probably will be very familiar with them, and some of you know them inside out, I'm sure. And then we'll go through some of the cases I just mentioned and the different readings they've been getting in commentary, both in practice and in copyright doctrine. And then what I also want to do is ask some more general questions about this process of what I think is sort of accidental or maybe a creep, harmonization creep that we've entered into. And then we hopefully have still some time for discussion. So first, the directives. What I've done here is list on the left-hand side the policy documents, the green papers and their follow-ups, and on the right-hand side the directives that have resulted from them. In the 1970s and 80s, there still was no secondary EU law on copyright, but the Court of Justice had started to apply primary law to intellectual property, so on freedom of goods, notably, but also on the non-discrimination principle later on. And in 1988, there was the first green paper on the challenge of technology. It announced action was needed in a lot of fields. Computer programs and databases were already on there, and they resulted in directives. We had the rental and lending rights, harmonization of the distribution right, which ended up in the Information Society Directive of 2001, the exhaustion doctrine, home copying was also a topic, and then the follow-up in 1990 added cable and satellite broadcasting and harmonization of the term of protection, which gave us the term directive, which has since been, or recently been revised. And then the 1995 Green Paper was all about adapting exclusive rights to the digital environment, even though the web was still not recognized by policymakers, I think, completely. So, there was a heavy focus on the scope of economic rights online and on DRM and technological protection measures, and the process ran in tandem with WIPO activity that led to the WIPO copyright treaties and the Performances Treaty. And interestingly, perhaps limitations and exemptions were not really on the agenda initially, although they have since become a big part of the Information Society Directive. The 2008 Green Paper was much more modest. It focused on some further exemptions and limitations, and the 2009 follow-up, so the last one on the list, deals with orphan works and the availability of works for persons with disabilities. And the Orphan Works Directive is currently before the European Parliament. And then this summer, the Commission launched a consultation on the distribution of audiovisual works online. And that could result in further action on collective management, but possibly also in strengthening the position of actual creators in relation to producers of audiovisual content. Anyway, as you can see from this overview, a lot of the initiatives to harmonize date from the late 1980s, and with the exception of the Information Society Directive or the instrument, all the directives, tend to deal with a very limited set of copyright issues. They only apply to certain works, or they only apply to certain types of exploitation. And from that perspective, I guess it's not surprising that you'll not find much reference to the work or who gets author status in the secondary EU law. If you look at all the directives and you sort of scan them for terminology, you see that only two of them really deal with harmonizing the subject matter of copyright, and those are, of course, the Software and the Database Directive. The Computer Programs Directive, so the software directive, requires member states to protect software as a literary work, but only if it is original in the sense that it's the author's own intellectual creation. And that, as I assume you all know, is sort of a middle ground compromise criterion to even out different local standards of originality. Especially older German case law set the bar for software quite high. So some countries went down with their standards as a result of the software directives, and others went up. And continental lawyers, of course, see the originality standard in the software directive as an instrumental UK-oriented approach, while on its face you probably see it as a continental personality-based type of test. Anyway, the database directive follows the criterion of the software directive, and it introduced a two-tier regime, and copyright proper is reserved for collections of works or material that constitute the author's own intellectual creation, and since the content themselves, facts for instance, need not necessarily be protected, it's the selection and arrangement of the contents that's sort of the central criteria. The database directive itself doesn't specify that the database must be protected as a literary work. It only talks of the database as an intellectual creation, and the same distinction you see in the WIPO copyright treaty. And if we look at the other directives, you'll obviously find the term work in all of them because, that's the default term we use to talk loosely about copyrighted subject matter. But these references tend to be in function of whatever the provisions are trying to harmonize or regulate. So, for example, in the term directive, which is about harmonizing the duration of protection, it does this for different types of works. If you want to harmonize the term of protection, you have to agree on how to calculate the term, and you have to give some provisions for the less straightforward cases, like what happens if you have several authors, what happens if there's not an identifiable author, what happens if the initial owner is not a natural person but a legal person, an immortal, of the kind that doesn't readily die. So, you need to have provision for that, and that explains why you get all these different types of works mentioned in the term directive. Another example in the term directive is the provision on photographs, which says that the term of protection for photographs is also life of author plus 70 years, but that only applies to photographs which are the author's own intellectual creation. And recital 17 then adds, reflecting his personality, which is a very German sort of phrasing. And the reason why the directive makes this distinction between the author's own intellectual creation photographs and others are because Germany and Austria, and I think also Hungary, have a two-tier regime for protecting photographs. Simple photographs which are not original are protected for a shorter period than proper original photographs. And of course, when the term of protection was harmonized, it had to be made clear that the 70-year term only applied to original photographs. That doesn't mean that the legislator intended to harmonize the standard of protection for all photographs. I think it's merely making a distinction between these two different kinds. And in the resale right directive, there's also a very particular reference to works, because the resale right, the right to share in the proceeds of sales of works of art, basically, it applies to a limited category of copyright works. And then in the Information Society Directive and other directives, you also see very general references to the work, often to distinguish it from other types of subject matter which is protected through related rights like broadcasts and phonograms and so on. I hope from the overview I've given, it's clear that at the political and the legislative level in Brussels, there really hasn't been much thought given to the work notion other than for software and databases. And the same is actually true for authorship. You know, who's initial owner, who's co-author in collaborative situations, commissioned works, and so on. So what has happened? How do we find ourselves in a situation where I think it's fair to say as a matter of EU law, we have a harmonised concept upon us, no matter how vague it still might be. The reactions on InfoPack were still very mixed in terms of what its impact would be, but the subsequent BSA ruling, I think, brought home that the Court of Justice is actually extending the author's own intellectual creation criterion that we know from the Software and the Database Directive to all other areas. And Football Association versus Murphy is, of course, a very recent case, so there's not much commentary out there, but it seems to toe sort of the same line. And just to recap on these cases, of which I'll spend most time on InfoPack, you probably know the facts of the case. There's actually a Blacka seminar on it over a year ago, I think, yeah. But for those of you who need reminding, InfoPack was a media monitoring and analysis business, and it provides customers with tailor-made summaries or snippets of newspaper and journal articles. So it's a sort of alerting service. So they scan printed newspapers and they ran customized searches on them, and then they sought a hit of a search term with surrounding words, and they mail these to the customer. And here's sort of an example of what a snippet would look like. And the search term here was TDC, which is a major Danish telecoms company. And the dispute was about whether InfoPack needed permission from newspaper and journal owners to do that. And the question the Court of Justice had to answer is this type of reproduction a partial reproduction within the meaning of the Information Society Directive, whose Article 2 says that the author has the exclusive right to authorise reproduction, also partial reproduction. And to be able to say something about that, you know, the court had to go into the work concept at some level, and that's why I think it said that copyright is liable to apply only in relation to subject matter which is original, in the sense that it's the own intellectual creation, the second bit there. And the court arrived at this concept by reference to the Berne Convention. It says the Berne Convention, when it talks about protecting subject matter as artistic or literary work, that presupposes they are an intellectual creation. And then it jumps to definitions in the Software and Database Directive, and from there onto the work in the reproduction provision of the Information Society Directive. So far, I think I've collected about 20 case comments and articles on InfoPack and BSA, and I can't recount what all of them say, but just to give you an idea of the type of argument made or readings giving. A first reading is that the Court of Justice recognised copyright in very short works, and especially in the blogosphere, you see this, 11 words are a work type of comments. I would personally go for a narrower interpretation. I mean, where the court talks about these now infamous works, 11 words, it was answering the question, when I take 11 words from a newspaper article, is that a partial reproduction within the meaning of the Information Society Directive? It's a reproduction right, and it says possibly if those 11 words reflect the originality of the article, and that means there's a threshold for partial reproduction. Not any quantitative amount of copying will do. The quality of what is copied also matters, and I think this is quite an uncontroversial point. It doesn't necessarily mean that an 11-word sequence in itself is a separate work or an original work, and that you can chop up a work in constituent nested works when it was never conceived of as a compilation or a collection. If you accept that 11 words sequence can in principle be original, you could say, okay, every line of a poem is a work unto itself, which sort of, I think, lands us in a kind of a messy situation. The second type of analysis, and that's the most frequent one you come across, is a fairly straightforward sort of compatibility analysis. Commentators take the word concept and the criterion of originality that the courts put forward, and they compare it to their local standards, and they say, so is this any different from the result that we would arrive at? And on originality, in InfoPack, the court said that since individual words are not copyrighted, it's only through the choice, sequence, and combination of those words that the author may express his creativity in an original manner and achieve a result which is an intellectual creation. Generally, in France and the Netherlands, and I guess to a large extent also in the UK, the conclusion of scholars and practitioners is that the standards of the ECJ are actually, when you apply them, yield the same result as our old or existing standards do, and nothing changes much except maybe the wording. But in Germany, there's criticism that this generalized standard is actually lower than what German courts would apply for certain work categories. And in other jurisdictions, I think also here that's said for applied art and design. Which brings me to the third reading, which is popular in Germany, is that InfoPack only sets a minimum standards. It's the common lowest denominator and a threshold that all works must meet, but national courts or law can still set a higher standard for certain categories of works. Fourth and fifth type of reading are not about the proper standard as such, but more about how the court arrives at it. The most biting criticism I've come across is by Stephen Housden. I don't know how to pronounce his last name, really. He unpicks what the court says it does in the InfoPack and BSA judgments and what it is actually doing, according to him. And his conclusion is, the court says its work concept and originality standards derive from the Berne Convention and from the database and software and term directives, but actually on originality, it's most likely that it follows a certain French textbook, and on BSA, a German textbook, or the other way around, I forget. But so he mounts an attack of the logic and the reasoning, and also the selection of sort of materials that the court uses in its judgment. And he links that to potential disagreement on what actually a proper standard would be for the copyright work. And it's a type of analysis that stood out from the others I've seen, I must say. More common procedural criticism of InfoPack and BSA is that the court has generalized the very particular standards for very particular works, namely databases and software, which are functional works for which the legislature had to find a middle way in terms of originality, as I've just explained, and that the court expanded it to all categories of works, and that this goes beyond what can be regarded as the acquis communautaire. So that's about the relationship between the software directive, the database directive, and the information society directive. But essentially, it boils down to the question, to what extent are the legal concepts in those directives autonomous concepts, or do they refer back to national law? And the criticism then is, sure, software directive, database directive, these contain autonomous European concepts, but the information society directive does not, and the term directive does not, where it concerns the definition of a work of authorship. And I think in the UK, Judge Arnold in SAS Institute did not accept that argument. He said the EU has legislated on ordinary literary works, and it has brought ordinary literary works within the scope of the acquis communautaire, and that's clear from InfoPack. It's true, but I think the question remains whether all the concepts and terms that appear in the Information Society Directive are autonomous. The trope today seems to be that if there's no explicit reference to national law in a directive, then it must necessarily be an autonomous concept. And that's something that's apparently exported from case law on customs union regulation, this type of interpretive method. And I think it raises some questions about how the methods of interpreting directives as legal instruments in other EU fields of law impact the reading of intellectual property directives, and to what extent policymakers are actually aware of, think ahead of how this impacts what it is that they think they're trying to achieve in terms of substantive lawmaking. Anyway, I think you can make the case that the legislature did not intend to harmonise the work of authorship as a concept or settle one originality test for all works, because it's not at all obvious, given all the known differences between national systems. And I've just put a couple on the slide here, and these don't capture, of course, the nuance you have in different local standards for different categories and jurisdictions, because laws tend to be quite concise when they speak of what a literary work is, and the real definition is, of course, in what the courts develop. In Germany, for example, the German black letter provision talks of works which are personal intellectual creations. There's only geistige Schöpfungen, and then the courts have elaborated what that means, helped by doctrine, tons of it. And the required level of originality is only one element of the work notion, and there are different standards for different types of works in Germany. With the highest test, I think, still for art and design. Another, I think, area which shows how problematic this idea is that we suddenly have this uniform concept is what happens with the accumulation of copyright and design rights after the Floss judgment of January this year. The 1989 Design Directive harmonized substantive criteria for national registered designs, and it also says cumulative protection under national design law and copyright law is possible. And then the 2002 Community Design Regulation, which introduced the community registered design and the unregistered design, says something similar. It says, I think I put it down here. The extent to which and the conditions under which copyright protection is conferred to designs, including the level of originality required, that is a matter for member states. So obviously you think InfoPack and BSA cannot apply to design. I mean, it's here. And Article 9 of the Information Society Directive also says it's without prejudice to provisions on design rights and patents and a host of other things. And the first proposal for the Information Society Directive predates the Design Directive. The first proposal was from 1997, and surely, I would say, if the Commission had intended to effectively neutralize the copyright clause of the Design Directive, which was, of course, also being legislated at the same time, it would have said something specific on the matter in the InfoSoc proposal or in later versions of it, which it did not. And then we have the 2002 Design Regulation, which repeats the Design Directive, and it's, of course, later than the InfoSoc Directive. So I really struggle to see how the court in InfoPack and BSA could be constructing a harmonized work concept for all works, including designs. But then in the Floss case, it says, well, an unregistered design may be a copyrighted work under the Copyright Directive, and it seems to refer, although it doesn't explicitly refer to InfoPack, it does use a phrasing which is very reminiscent of the InfoPack case. And the Floss case was about Italian design law, and they had some trouble with transitional law because previously designs could not be protected under copyright and design rights in Italy, and so they had to change that, and there were some questions about what transitional law was acceptable. So I don't know. This is one of the more difficult, I guess, cases to interpret or make sense of. Because the court in Floss takes a very narrow reading of this Article 17, which says it's up to member states to decide on copyright protection. It says cumulative protection is not optional but mandatory for registered designs. So registered designs must be copyright protected if they meet local criteria. And the design directive doesn't apply to unregistered designs, so it doesn't force countries to grant cumulative protection, but the court seems to say InfoSoc directive, as we interpret it in Infotech, applies to unregistered design. So what does that mean? That we have like the unified software database standard for unregistered designs and a potentially higher local one for designs that are registered? I mean, that doesn't make sense at all, although, it would be a logical consequence. It doesn't make sense in practice, because it would make the application of a substantive copyright standard dependent on some aspect of another type of IP right, the design right. And then I don't even begin to understand what would happen to the community registered design and community unregistered design right in relation to copyright. Anyway, I think the confusion over how to interpret these cumulation provisions in the light of the Information Society Directive, they only show how shaky the ground is on which the court is building. It's fair to say before InfoPack prevailing opinion was, even though there are great similarities between the type of creations that are protected in member states' copyrights law, it's not harmonized subject matter, except for software and databases. A quick look at BSA, which was about the protectability of a graphic a user interface as part of a computer program. So much of it is about the interpretation of the concept of software as it used in the software directive. But for our purposes, what is important is the second bullet point, that the court explicitly refers back to InfoPack and seems to sort of reinforce the reading that InfoPack did in fact introduce a harmonized work concept. I think in the UK, Jonathan Griffiths noted that this seems to spell the end of having a limited number of work categories in your local laws, and that EU law requires an open-ended work of authorship sort of broad category, which for continental jurisdictions is not a problem because we already do it that way. But obviously for the UK, it's problematic. What I miss primarily in BSA, and I think it goes more or less to the same problem, is that there's a blanket reference to the criterion in InfoPack to the own intellectual creation, but there's nothing really about the domain of intellectual creations, artistic, literary, or otherwise. And Football Association versus Murphy takes that, one step further. So this has been in the news, of course, a lot here, primarily because of its impact on the licensing of broadcasting, sports events in broadcast licensing. But it also says things about the work concept on whether a sports event, a football game, is a work. It's an intellectual creation. What I've highlighted here are the considerations which are about whether a football game is a work. And I agree with the conclusion, the answer that no, a football game is not a work, but not with the reasoning. In this case, there's a sports event, it's captured for broadcasting, footage of the game is enhanced en route to the viewer, so there's logos added, and there's commentary and graphics and so on, all kinds of elements which could give rise to copyright. But the question that the Court of Justice answered is the sports event, the naked sports event, is it a work? What it says is, no, it's not a work, because of the rules of the game. They leave no room for creative freedom for the purpose of copyright. And here I think it seems to conflate the originality test with the work concept. I mean, in the continental tradition, your first question is it a type of creation or an object or a thing that belongs in the copyright domain? Is it, the work of literature or art or science, or even more broadly in intellectual creation. And then you ask, is it perceptible to the senses? And in the UK you would ask, is it fixed in some form, which is a requirement quite specific to UK law. And if your answer, or your tentative answer is yes, and then you ask, is it also an original creation? I mean, it's an additional requirement. And here you would say, does it show the right kind or amount of skill and labor? And the court just ignores the domain and other questions and jumps to saying there is no work because the rules of the football game leave no room for creative freedom. And I'm not a particular football fan, but I would think that creativity, not just sort of like in moves, I don't know how that's what football players do. No, I'm not that. I don't the tiniest bit about football. But anyway, so and in the games, and strategy and so on, and that creativity in those areas is widely recognised and valued by fans, even if winning is all that counts in the end. And the court's reasoning sort of reminds you of saying, a particular poem is not an original work because it has the formal properties of an Italian sonnet as a poetic genre. And that's that a chosen form or an intended functionality limits the creative freedom of the author and impacts the thickness of the copyright, if you will. I mean, that's beyond dispute. And in BSA, the court actually says it much, where it says expression that is dictated by technical function does not count towards finding originality. That's generally accepted. But as far as I know, the reason that sports events are generally excluded from copyright is because they're not seen as works full stop. It's not about levels of creativity, it's about the kind of creative activity and the result of that activity as a genre, if you will. So that's one step back from determining whether a standard or originality has been met. Anyway, these four cases that I mentioned are going to be followed up by a number of others. That there's a rise of preliminary references about the work, and two big ones are from the UK, of course, and the Football Data Co. on copyright and databases, which will answer questions, hopefully, about what kind and level of skill or labor are required. And then we have the SAS Institute case on what counts as computer program, computer manuals protected as literary works, status of programming languages, and so on. And another case is an Austrian reference on photographs, which ties in what I explained earlier about the distinction between original and simple photographs made in some jurisdictions. And undoubtedly there'll be many more. So I think maybe just a few observations on sort of the preliminary reference as a tool to achieve actual harmonization, where directives contain vague norms. If you look at the process, I think there's a number of characteristics that drive sort of the export of the software and database criterion to all copyright works, but it's also a process that involves a fair amount of uncertainty and accidentalism. And the first feature is that it's of necessity locally driven, of course, because it's national courts that decide whether to refer a question to the Court of Justice, and the Court of Justice only in very exceptional circumstances can say it's not going to answer a question. And I think that the process is locally driven also makes it interesting to see empirical work. You sometimes hear things like, "Oh, German courts, they're not too keen to refer questions because they're afraid they won't like the answer," or that Dutch courts they don't ask questions because they think they can read the Court of Justice's mind anyway. I'm not sure whether that's all true, but it'd be interesting to see, to get some hard facts on IP law, how it's formed in Luxembourg through preliminary references and instrument. I've not looked at it, and I'm just kind of hoping somebody is somewhere. But how many IP cases get referred in relation to sort of the total cases, IP cases in the jurisdiction, and where are they from, and do they share characteristics? Are they cases that intend to involve large economic interests or certain industries, or are they on certain types of works? And I suspect that sort of the type of cases that get referred refer to the court, contribute to the kind of language, if you will, that the Court of Justice develops for copyright law. And a second characteristic is I think you can get sort of a snowball loop effect. By nature, preliminary references are questions on the interpretation of a provision in a given directive, and that frames the way in which the court gets asked about the copyright work, and then the court can frame it some more in its own way. But for example, in the software directive, the idea-expression dichotomy is quite present. So if we get questions which sort of refer to that idea, is that going to filter through in other areas or not? I'm not sure. But anyway, if the court gets these questions, has to answer it, does it primarily by looking at the wording of a directive and its stated objectives, and not on the sort of social role of IP, for instance. But it looks quite narrowly at the stated objectives in the recitals, and also with an integrationist agenda. And then that answer is used to decide cases in member states, which generate new preliminary references, and you sort of get this loop thing going. And a final point I was wondering about is how likely is it that the courts get the most difficult questions about works on the edge of protection on hard cases, and is there a risk that hard cases make bad law? I mean, there's much more to be said about the preliminary reference procedure as a harmonization tool, but to be honest, I've never really given it much thought before the court started coming up with these cases. So I don't really feel at home in the topic yet. But I think, now that the court shows itself to be so activist and willing to construct pan-European notions of copyright, which are not that clearly in the directives, I mean, I think it's important for IP scholars to give more scrutiny to the reference as a tool, or the mechanisms of how this work. So just to round off, so we have a little time for discussion. I guess by now you're aware that I think at the political and legislative level in Brussels, not much thought has been given to the copyright work other than for databases and software, and that these are problematic genres in terms of fitting them in traditional notions of the literary or artistic work categories, which explains in part why they got so diverse treatment in member states in the 1970s and 80s, and which was why the need for harmonization was acute. But legislating for very particular works, types of work, doesn't necessarily make for good general standard, I guess. I think I can also, I also have a bit of a democratic legitimacy problem, I suppose, with the way things are going, because in the EU institutional framework, there's no realistic way back to localism. It's sort of like a one-way street. Once the court decides to expand European law in a certain area, there's not a realistic way back from it. And that's, and considering that how many questions still are going unanswered about what the relevance is of the domain of copyright to defining subject matter, whatever happens to the requirement of fixation in UK copyright law, I have no idea. Government information as copyright work is another area where there's a lot of diversity in national laws. The freedom to introduce or maintain copyright-like rights for subject matter that the court says is not a work. In Murphy, it specifically said, no, countries are free to introduce rights, IP rights for, or IP protection for sports events if they want to. And then we haven't even started on authorship, in collaborations and employment and commissioned works. There's an impressive number of issues, I think, that need clarification. And on balance, I suspect you get a better law and maybe a shorter period of legal uncertainty and more democratic legitimacy in an area of law that has become pretty politicized. If the legislature were just to take it up, rather than being dependent on sort of uncoordinated iterative process that we enter with this sort of accidental harmonization through the preliminary reference procedure. But then again, I have to admit I'm not a big fan of process lawmaking in IP so far, so so taking a position is a devil's choice, and maybe they all should just back off and go for sort of like an organic networked development of copyright. So anybody with alternatives, let's discuss. Thanks.